Okay. Going live in 5, 4, 3, 2, 1. We are live.
Good evening. Welcome to the February 26, 2026 Rental Housing Committee regular meeting. This meeting will be called to order at 6:01 p.m. I will proceed with roll call. All members are present with the exception of Emily Stott-Sislop. Moving on to item 3, consent calendar. These items will be approved by one motion unless any member of the committee wishes to remove an item for discussion. The purpose of the consent calendar is for the committee to efficiently and quickly consider routine or administrative business items with one motion. Public comment will occur after discussion. We invite you to submit a speaker card now if you'd like to speak on this item during public comment. Would any member like to pull an item? Seeing none.
No.
Oh.
Somebody unpressed me.
Vice Chair Cox.
Yes, I just want to make my customary comments on item 3.3. Okay. And,
Hang on.
oh,
This is for, this is just for polling. We have to do comment first.
Oh,
then we can
okay,
do-
fair enough.
Then we can do,
all right.
if no one polls. And I now invite public comments. In-person public comments will be called first. Seeing none, we'll move on back to this item back for committee action. I'll go back to Vice Chair Cox.
All right. I just wanted to make, as I said, my customary comments on 3.3, the Rental Housing Committee report, and on market conditions. And I wanted to note that it appears that rents on newly constructed units, meaning since the CSSRA has been passed, are up and up at an annual rate of greater than 6%, which is about twice inflation. And it seems that that may have had a tendency to pull up on the vacancies as well, which, make them go down another 2% to 8.5%. So it means that the vacancies are getting filled and at higher rental rates. On rent-controlled apartments, it's pretty close to being stable with a 0.3% increase in the vacancies and a slight $25 decrease in the rents. So one of the things that I did to try to understand the basis for this, I went into the California Department of Finance and checked the population figure estimates for our city over the last 15 years, and they claim that our city grew by 2,978 people last year, which was the highest increase in 15 years. So that's kind of an interesting thing. Anyway, that's what I just wanted to mention. Thank you.
And does anyone else have any comments? Otherwise, a motion is in order. Member Brown.
I move to approve all items on the consent calendar.
A motion made by Member Brown, seconded by Vice Chair Cox. Seeing no discussion on the item, we'll go to a vote. That motion passes unanimously, and for the record, Emily Stott-Sislop is now in the dais with us. Moving on to item 4, oral communications. We will now open this meeting for oral communications from the public. This portion of the meeting is reserved for persons wishing to address the committee on any matter not on the agenda. Speakers are allowed to speak on any topic for up to 3 minutes during this section. State law prohibits the committee from acting on non-agenda items. Would any member of the public like to provide comments on non-agenda items? Please raise hand on Zoom, press *9 on your phone, or submit a blue speaker card. Seeing none, we will now move on to item 5.1. This agenda item will include in-person interpretation. The Rental Housing Committee, in hearing the appeal, is acting in a quasi-judicial fashion and will conduct the hearing in accordance with those standards. Staff will detail the hearing process in their presentation. Before we get started, RHC members are required to disclose any communication that they have had with any of the parties to the petition or the party's representatives and the substance of those communications since the date that the petition was filed. The decision of the RHC is to be based on the record presented to the hearing officer. Information disclosed to an RHC member that is not part of the record is not to be considered in the hearing. Do any RHC members have ex parte communications that need to be disclosed? Seeing none, we will now proceed with public comment on agenda item 5.1. Are there members of the public who are not parties to the petition who would like to speak? Please raise hand or press star 9 on your phone or submit a blue speaker card. Seeing none, we will now move to agenda item 5.1, appeal of hearing officer's decision regarding petitions number 2526-2 and C2526-3. We start with a staff presentation.
And can I just say before we start, we do have translation, so if you can please speak slowly to allow time for translation. Thank you. Okay, thank you. So the purpose of this item is to consider the tentative appeal decision and either accept the tentative appeal decision or modify it with instructions to staff, citing appropriate evidence in the record to support any changes that are made. All right, so just a summary of staff presentation. I will review the Rental Housing Committee's decision process. I'll discuss the schedule for the appeal hearing, and then I will do a summary of the petition and the appeal. So the Rental Housing Committee's options for this appeal are to decide the appeal on a closed record, which means based only on the facts and the evidence in the decision written by the hearing officer. An open record, in which case you would follow formal hearing procedures and potentially accept new facts before arriving at a decision. And finally, a remand, in which case you would follow the closed record procedures, but you could identify specific issues for the hearing officer to re-examine, including potentially accepting new facts or evidence. So the Rental Housing Committee, for questions of law, such as statutory interpretation, must exercise its independent judgment, and for questions of fact, must determine whether each appealed element of the hearing officer's decision is supported by substantial evidence. This does not mean that you reweigh the evidence or relitigate the issues, and the appeal is still based on the record submitted to the hearing officer, so no new evidence or that was not put forth at the original hearing may be put forth on appeal, but that does not mean that you have to come to the same conclusions as the hearing officer. So staff is not recommending a de novo hearing this evening for this appeal. Not only would it require significant time to prepare, but the existing evidence in the hearing record is sufficient, and it demonstrates adequate review and ample opportunities for the parties to have presented the relevant evidence. So just as a reminder, the petition, meaning the issues that were raised by the petitioners in their petition, define the scope of the hearing officer's decision. And similarly, the issues that were raised by the appellant limit your review on appeal, your scope of review. So you don't need to go outside or consider additional questions beyond those that are raised by the appellant in this case. So the schedule for the appeal hearing, in this case, the appellant is the landlord. They will start off with a 10-minute presentation. In this case, it's double the time to allow for translation, so up to 20 minutes, followed by, similarly, 20 minutes for the petitioners or the respondent tenants in this case, because they also require translation, followed by 10 minutes each for rebuttal for the parties. Following their presentations, the RHC can ask questions to staff, followed by questions for It should say appellant landlord and the respondent tenant, and then finally conclude with deliberations and your decision. So just before I get to the appeal elements, I'll note that this appeal included 2 petitions. The first is this case involved 2 petitions. The first is for unlawful rent, based on 2 things: the landlord's failure to register the property in 2021 and 2022, as well as the landlord's unlawful addition of a fee that is comprised of a latchel fee, renter's insurance, and service fee. And the second petition raised both habitability issues as well as decreases in housing services, and there were a number of those. But the issues on appeal do touch on both of those, so it's worth mentioning that it does go to both aspects of the petitioner's original petitions. So on appeal, the landlord raises 2 issues. The first is that the hearing officer erred or abused her discretion in holding that the respondent landlord, in that case, was liable for unlawful rents resulting from the prior owner's failure to register the property in 2021 and 2022. And the second issue is that the hearing officer erred or abused her discretion by concluding that petitioners were entitled to a rent reduction for the mold and moisture conditions in the affected unit, because the landlord took timely steps to correct the issue. So the tentative appeal decision recommends affirming the hearing officer's decision in its entirety. So the hearing officer did not err by concluding that the landlord was liable for the predecessor's substantial noncompliance with the CSFRA. The language of the CSFRA expressly imposes liability on landlords for violations that started with a prior owner and continued with the landlord when the landlord assumed ownership. So that was not an error in statutory interpretation or application by the hearing officer. In addition, the hearing officer did not err or abuse her discretion in holding that the landlord was liable for moisture and mold conditions in the affected unit. The hearing record clearly reflects significant delays of between 14 and 30 months in correcting the moisture and mold conditions throughout the various rooms in the unit, and those delays are not reasonable and are not excused by any of the factors that were identified by the landlord, such as the scope of the issue or, the lack of funds or any of the other, or weather delays, any of the other explanations that are provided by the landlord. So after the tentative was issued, the appellant landlord did submit a reply. In the reply, the landlord, to summarize, raised the following facts and additional issues. First, that the property was registered on December 11th, 2022 by the property management company that was hired by the landlord, not the predecessor in interest, but the one who is the current owner. And therefore, they did come into substantial compliance with the CSFRA at the time that the 2022 rent increase was imposed. The second issue that's raised is that the closet door was not a habitability issue, and also that petitioners were responsible for breaking said doors. The third is that larger trash bins were eventually replaced or put back, and that the landlord's contractor observed petitioner dumping landscape debris into the larger bins, and that was part of the reason why they moved to smaller bins for the period of time that they did. And then finally, that the landlord should not be liable for the moisture and mold because there were 6 people living in the affected unit, which exceeds the state occupancy limits. So the additional facts and issues raised by the appellant's reply do not change staff's recommendation as far as the tenant goes. Generally, several of the arguments that are raised in the reply and the information provided by appellant in the reply should have been raised at the hearing. For instance, if they believe that the petitioners had some culpability in any of these issues, then they should have raised that at the hearing and provided evidence of that at the hearing, but did not do so. So that does not change the analysis that based on the record that was before the hearing officer at the hearing, she did not err or abuse her discretion, and her findings of fact and law were supported by substantial evidence. Even if the appellant had presented evidence to the hearing officer to show that the property was registered on December 11th, 2022, the property was still out of compliance at the time that the November 1st, 2022 rent increase was both noticed back in October of 2022 and at the time that it went into effect. So it was still invalid. It could not have been issued until after they came into compliance with the CSFRA. In addition, both state landlord-tenant law and the CSFRA follow Section 503B of the Uniform Housing Code for occupancy limits, not the 2+1 rule, which, for those who don't know, means that you take the number of bedrooms, you multiply by 2, and then you add 1 person to that. So in a 2-bedroom, based on that limit, you could have a max of 5 people. However, under the Uniform Housing Code, the occupancy limit is calculated differently based on square footage. And none of that evidence was provided at the hearing, so there's no way to determine if they did in fact exceed the occupancy limits. And moreover, even if the 6 people in the 2-bedroom did exceed the occupancy limits, the landlord has not demonstrated any causation between the number of occupants and the moisture and mold conditions in the unit. Finally, any arguments regarding the broken closet door and the trash bins were not raised in the original appeal and are therefore untimely. The reply is limited to addressing issues that are raised by the tentative appeal decision and cannot raise new issues. So fiscal impact, any decision by the committee on appeal could potentially lead to litigation, which would have fiscal impacts. But one of the purposes of having an appeal process is to ensure that hearing decisions are legally defensible, and so the appeal process to the committee reduces overall risk of legal liability and legal expenses. So again, staff's recommendation is to consider the tentative appeal decision, either accept the decision or modify the decision with instructions to staff citing appropriate evidence in the record. Thank you.
Thank you. Appellant landlord, please come to the podium if you are choosing to speak. There will be a timer right here. You would have 20 minutes.
Yeah, I might need it. Yeah, especially when you guys say something, I can't hear too well. 'Cause the
如果你要是用英文讲的话是10分钟时间，他现在不听。OK， 他现在需要花时间。如果你要讲英文的话，他就给你10分
I
钟。
think Okay, thank you for the time, for giving me the opportunity to make my case. Okay, sorry, a little nervous. Thank you for the time.
Just
Can
pretend you're
you
eating
hear?
the mic. Like pretend you're about to eat it.
Okay. Okay. Thank you so much for the time. Allow me, for the opportunity, allow me to speak about my case. I purchased this 6-unit apartment building in June 20th, 2022. I'm a very small landlord. I was excited to invest in amazing city of Mountain View, but I have no idea how complicated the rental law is. So shortly after that, I signed up a property management company, and then they doesn't look like they registered the moment I signed the contract with them. It seems they waited a couple months, I don't know why. Then they registered the property in December 11th, 2022. In the meantime, we did have a rent increase because 2 of the units, the renter moved out. We had to do some major repairs. So we had a rent rate increase. So the hearing officer said the whole time from the rent was increased to end of 2025, the whole time the rent increase was unlawful. I thought that's not fair, and because a month later we registered the property. So after registration, the rent increase should be legal, lawful. So I'm first-time landlord. I really don't know all this. I think the ruling of returning $8,528 is not fair. It's a lot because we did register the property. So the second issue is the habitability issue. Okay, first I want to go with the easy items. Broken closet door, it shouldn't be a habitability issue. The tenant continues to stay there, enjoys the premises. Actually, all the units, the rent is actually below the market. I feel I'm really contributing to affordable housing. But anyway, the broken closet door, due to the old configuration of the closet, it takes a long time to figure out how to address the issue. Eventually, we have to burn down the wall, burn down the drywall so we can buy the kind of closet we can get from Home Depot, because the old closet door is all the way to the ceiling. But in any way, the closet door shouldn't be considered a habitability issue. Then the other problem is the inadequate trash. Because the tenant or outside people, they come in the complex, throw all kinds of trash, couch near the dumpster. We have a big dumpster. And then I thought, we also have lots of recycling bins. So I thought, oh, let me replace into smaller trash can, just like a single family house. We can pull it out. Each family have their own can. And then they objected the change, not only this unit 2, also other people complained. So I brought the large container back. That doesn't affect in habitability. Shouldn't be ordered to return money back to the tenant. Then the more bigger issue is the moist and the mold. That's a ongoing issue with this unit. We have 6 units. Somehow nobody else had this issue. But started from what they tell me, I continuously made lots of effort, try to fix the problem. First is they have some mold on the wall. We don't know they are cooking too much. When they shower, they don't vent it out. We just keep on addressing the issues one by one, from small to bigger. Eventually, we replace the floor with LVT hard floor. We changed the brand new window, double pane window. Also, we replaced the whole bathroom. They are all big ticket items. Eventually, we even rip out the outside wall to check what's going on and added more insulation in the wall. So all these large items, I spent over $20,000. And then now the ruling to return to the tenant is excessive, creates huge burden to a landlord who wanted to improve the property. So I ask the committee, honorable committee, to adjust the ruling. I do take some responsibility and not fast enough to fix some issues, but I want to ask you to reconsider and adjust the ruling. So can you say something? Okay. Do you guys understand what I said? Very well. Okay. How much time I have?
2 minutes and 20 seconds.
Only 2 minutes passed? 2 minutes left. Okay. Okay. Do you have any questions?
Questions will be done after the speaking portion, so if you have nothing further, you don't have to speak another 2 minutes.
Okay. Let me see.
Andrea, can you put the
Okay.
timing slide up there?
So the other point I want to make is, so I am a small landlord. I'm making all the efforts to actually improving the properties. We completely remodeled the 2 units. The extra rent I get is minimal. If I don't remodel, I get maybe $2,800, but I remodel, I got $3,000. Due to the location of the units, the rent would not be super high. So I invest $30,000 in improving the unit. The rent increase is $200 per month. So that takes more than 10 years to get the investment back. But I do it anyway, even though some people said, landlord, you don't need to do anything, just rent it out. I'm not that kind of landlord, only want to charge because I care about my property. I honestly did all the improvement, especially for this unit. All the problem they mentioned, it's all resolved. So that's all my marks. Thank you.
Thank you. You'll come back a little bit. You'll come back again.
You can, adjust my the amount.
All right. Respondent tenant, please come to the lectern. You will have 20 minutes if you are including a translation.
Mi nombre es Blanca Zamora y vivo en la propiedad del 207 Evandale y soy la demandante.
Mi nombre es Gerardo Robles y también vivo en Mountain View, en el 207 Evandale, y también soy el demandante.
Hello, my name is Blanca Zamora, and I live at 207 Evandale. Hello, my name is Gerardo Robles, and I also live at 207 Evandale.
Voy a empezar hablando sobre lo que le ha dado muy poca importancia y para mí es lo más importante, que es la salud de mis hijos.
I'm going to start by saying that the most important thing to me is the health of my children.
Hay un antes y un después de esta situación. Esperé 2 años y 9 meses para que se arreglara el problema del mojo en el cuarto de mis hijos.
There is a before and after to this situation. First, I waited 2 years, 9 months to have the mold situation in my child's room taken care of.
Durante todo ese tiempo, traté de mantener la unidad lo más habitable posible.
During this whole time, I tried to keep the unit as habitable as possible.
Reemplacé camas, colchones, compré un purificador de aire, compré deshumidificador y aspiradoras para que mis hijos pudieran tener una calidad de vida mejor.
During this time, I had to replace mattresses and pillows and blankets. I also had to buy an air purifier and a dehumidifier and a respirator just so that my children could have a decent life.
Durante todo este tiempo hemos sufrido alergias por causa del mojo, especialmente mi hijo de 9 años, quien ahora depende de inhaladores para poder vivir.
During this time, my children developed allergies, which they didn't have before, and the worst because of the mold. And my 9-year-old child suffered the most and now has to use an inhaler just to breathe.
De ser un niño que era activo y jugaba soccer, ahora está inactivo, pasa noches sin dormir, ausencias prolongadas a la escuela y todo porque la situación del mold le afectó.
My son used to be very active. He used to play soccer, but now he's very inactive, and he spends sleepless nights and has missed a lot of school just because of the mold situation in the unit.
No considero que ninguna cantidad sea suficiente para devolverle la salud a mi hijo o a toda mi familia.
There is no amount of money that would be sufficient to replace the health of my child or my family.
No es verdad que las otras apartamentos no tienen mold. Claro que lo tienen y ella lo sabe. Ha podido arreglar los últimos meses casi todos por el problema del mojo.
It's not true that the other units don't have mold. It's just that she doesn't know about it. There have been other problems in the other apartments.
Esperé 14 meses para que se removiera la carpeta del apartamento, porque también, aparte de vieja, tenía mojo.
We had to wait 14 months for them to change the carpet in the apartment. Not only was it old, but it also had mold growing in it.
Aunque se lo hice saber por las razones de la salud de mi hijo con una carta y una nota del doctor, nunca me dijo que no, pero no lo hizo el suficiente pronto para no enfermar a mis hijos o para revertir la enfermedad.
I even gave her a note and a letter from the doctor saying that the mold was causing health issues for my children, and she never said that she wouldn't take care of the problem. It just took her a really long time.
Duré 3 años esperando para que se arreglara el baño, que también tenía moho, y algunos problemas de la regadera.
We had to wait 3 years for her to fix the problems that were happening in the bathroom, such as the mold growing there and that the shower wasn't working properly.
Estoy nerviosa, lo siento.
I'm nervous, I apologize.
También he esperado desde el 14 de abril hasta la fecha a que se reemplacen el refrigerador que se descompuso y ella lo reemplazó por uno más pequeño, el cual pues no es suficiente para mi familia y no era el que cuando entramos teníamos la misma la misma altura y la de grande, no era lo mismo.
We've been waiting since the 14th of April for a new refrigerator that was malfunctioning. And when we got a new one, it was a lot smaller than the original. And the refrigerator that she replaced it with isn't enough for my family. It's too small.
Cuando mi esposo habló de que era más pequeño del que teníamos cuando nos movimos, ella textualmente le dijo, compra otro y cuando tú te vayas te lo llevas.
And when my husband said that this refrigerator is not big enough for us, she said, buy another one, and when you do, then I'll give you the money back for it.
Durante el tiempo el proceso de cambiar la carpeta y poner piso, duramos 3 días, mi familia y yo, sin acceso a la cocina y a los dormitorios.
In the time that it was taken to replace the carpet, which was 3 days, my family didn't have access to the kitchen or the bedrooms.
Y aunque le pedí un cuarto de hotel, nunca respondió a mi pedido.
And when I asked for her to put us up in a hotel, she never answered me.
También cuando arreglaron el baño, no tuvimos acceso a la regadera y aunque mis hijos juegan deporte, mi esposo llegó, quería bañarse, me dijo que después me iba a reembolsar $200 y nunca lo hizo.
In the time that it took for her to fix the bathroom, we didn't have access to the shower. And my children play sports, so they need to shower. And also my husband, he works, so he needs to shower too. And she said, well, I'll give you $200 for the inconvenience, which she never gave it to us.
Esperamos 3 años y 6 meses para que la lavadora pudiera funcionar. Para mí, lavar en la lavandería pública fue difícil y más costoso. Nunca antes habíamos dejado de tener lavandería ahí.
We had to wait 3 years and 6 months for her to fix the washing machines. And during that time, we had to use the public washing machines, which was difficult and very expensive.
También nos sentimos acosados por medio de la agencia que la señora propietaria contrató para manejar la propiedad.
We also felt under scrutiny and accused by the rental management company that the landlord had hired to maintain the property.
Constantemente nos envían correos exigiéndonos pagar una cantidad adicional al pago de la renta de $72.50 por seguro de inquilino y mantenimiento.
We also received emails from this company asking us to pay an additional $72.50 for security deposit or just the maintenance of the property.
Aunque yo les decía que en mi contrato no figuraba eso, no había ninguna adicional pago, ellos seguían insistiendo y me dijeron que iba a pagar una cuota extra por incumplimiento de pago.
Even though the rental agreement never stated anything about an additional payment, they insisted that we had to pay the additional fee and also threatened to make us pay an additional fee for non-compliance with the payment additional of the $72.50.
Ahora, en cuanto a los contenedores de basura, tuvimos varios meses con la basura afuera de los contenedores porque eran muy pequeños, y a mi esposo le hizo saber que había basura alrededor, había roedores como ratas y otros animales.
In reference to the trash containers, they were too small for a really long time, and so the garbage was overflowing out of them, falling onto the ground, which made rats and other animals come and start eating the garbage, and it was a health hazard.
Y finalmente, como lo reconoció, los reemplazó, y también la cerca que está por la parte de los parqueaderos, la cambió y puso una más pequeña, lo cual gente que no era de ahí entraba a robar, lo cual nunca antes había pasado. Se lo hicimos saber y puso una luz, pero no todas las responsabilidades caen sobre nosotros. Ella dice que, perdón, puedes hablar.
And there was a fence that was replaced, but the fence was a lot smaller than the previous one, which allowed people to jump over it and come and steal things.
Ahora quiero contestarle sobre lo que dice que... ¿Quieres hablar tú?
No.
Que mi esposo le había dicho, el constructor, que mi esposo había tirado basura en el contenedor de los apartamentos. Voy a contestarle.
I also want to say something about her saying that my husband, who's a contractor, she was saying that he was dumping garbage into the garbage cans.
No sé por qué tiene confianza esta persona, ni siquiera es un constructor, no lo es porque no trae una licencia. Probablemente ella lo sabe porque dice que nunca se la ha pedido. Hablé con él y no sé qué tanto le haya dicho, entonces no sé por qué le cree que nosotros tiramos o mi esposo tiró basura ahí. Es una persona muy poco confiable, muy poco profesional. Cuando fue a trabajar ahí a la casa, hizo cosas que no eran profesionales. Le pedí yo la licencia, me dijo que no tenía, que no tenía por qué enseñármela, que ella nunca se la pedía. Entonces, solamente aclarar esa parte.
The person that she hired to do the work in the house, I don't understand why she trusted him. He seemed like a very untrustworthy person. and he did things that were very unprofessional. And when I asked him to show me his license, he said, no, I don't have to show you my license, and was upset about it.
Nada más quiero decirle que cuando necesite hablar con nosotros, ella tiene el número, puede contactarnos y preguntarnos. Ahora, si quiere saber lo que pasa realmente en la propiedad, necesita realmente poner un manager, porque sí pasan cosas y no necesariamente tirar basura que no corresponde ahí.
The landlord has our number and can contact us whenever she wants. I don't know why she was saying that we were doing things like throwing garbage in the garbage can when we weren't.
Creo que es todo. ¿Cuánto tiempo? 4 minutos.
Es okay. Si no te lo acabas, está bien.
Está bien. Creo que por... Yeah, es todo.
Okay, thank you. I'm finished for now. Thank you very much.
Thank you. Appellate landlord, you have 10 minutes to rebut any statements made by this respondent. Please limit your comments to rebuttal rather than repeating information. Yeah, 10 with translation, 5 otherwise.
Everybody's time. So first, tenant said takes 3 years to fix the laundry room. So the situation of the laundry room is it's a small room. The previous landlord leased one old dryer and one washer. Sometimes they break. So then we call the company who leased us the equipment to repair. It's on and off. So it doesn't take 3 years to repair it. It did have times that's not working. That's a fact. And then she said 3 days carpet replacement interrupted her normal livings. And also 1 day we replaced the shower. I hired a company called the American Showers to replace it because they're really quick, they're really fast. So I think for those, my property manager told me I shouldn't charge the rent for those days. So that's not a problem. We can waive those days for the rent. Waive the rent for those days. And then she said, scrutinized, watched over the shoulder by the property management company, because we need to bring order to the property. Like we just had a fire inspection. The fire extinguisher was blocked. We have to send out notices to tenant. Do not leave shoes, toys, random stuff on the doorway to make sure everybody is safe. I think that's just normal management. But those are not important stuff. The most important things still go back to the habitability issue, the mold. The tenant described a dire situation that her kid's life was threatened. Then I'm just thinking, oh my God, why don't they move out if the kids' our health are affected so big? There was mold. I take responsibility, but I don't know the severity of the health that's affected their family. I think that's all.
Thank you. Respondent tenant, you will have 5 minutes to speak with 5 minutes allowance for translations. To rebut any statement that was made by the appellant, please limit your comments to rebuttal, then introducing or repeating other information.
Quiero responderle sobre por qué no me mudé. No tengo las posibilidades que ella tiene. No es verdad que es una pequeña propietaria. Ella,
Por lo que hemos escuchado.
por lo que el mismo que le trabaja mucho a ella, que dice que es constructor y no lo es, dice que tiene apartamentos alrededor de aquí de la bahía y que tiene negocios. Entonces, no tengo las posibilidades que ella tiene para mudarme, nada más así. Su responsabilidad era inmediatamente contratar a alguien que supiera de exactamente de dónde venía el mojo.
I'd like to address the fact that she said that if my lives were being threatened by the health conditions, well, why don't I just move? Well, I didn't have the opportunities that she has. You know, I can't just take my family and move. I don't have, you know, the wealth that she might have. I don't have, you know, an apartment building like she has. She says that she's got, you know, other properties, other stores. She has different opportunities than I do. I can't just leave and find another place like that.
No soy yo la que fijó la cantidad, no somos nosotros que hemos fijado la cantidad que debe de reembolsarnos. Yo solamente quiero que sepa el daño que hizo por no actuar rápidamente y lo demás se lo dejo a ustedes.
It wasn't me that made the decision on how much that she needed to pay back. All I did was mention, you know, the damage that had been done and how long it took her to take care of the situation.
Eso es todo.
Okay, that's all I have to say.
Thank you. All right, we will now bring this back to the RHC for questions. Does any member of the RHC have any questions for staff? Vice Chair Cox.
Yes, just a few. So I'm wondering, does the RHC staff notify landlords who come before, you know, this hearing officer decision on what previous decisions have been made that may influence, you know, what will happen to them when they come up here for an appeal hearing?
Staff does not give opinions on the validity of the cases or the comparison with other cases.
I didn't ask about opinions. I asked if you talk about, give the facts of previous decisions that have been made. I understand they don't set a precedent, but I'm just wondering whether the information is given.
We don't.
Okay, thank you. And a question is, one thing that concerns me about what was in the hearing officer's report is that there was no information on the exact date when the registration was completed. And so I'm asking that if the committee were to remand this back to the hearing officer to get that information and consider it, in her opinion, would that be a legal action for the RHC to do?
Can you expand a little bit on what you mean that there was information in?
No, I said there was not information.
Oh, you said there was not. I'm sorry.
There was not information about the date of the registration. And so I'm asking if it would be a legal action for the RHC to remand the decision back to the hearing officer to get that information in the record so that she could consider it, you know, as to whether she would modify her decision.
You certainly can remand and ask her to get more information.
Okay. Let me see. Okay, I think those are my own two questions. Thanks.
Member Keating.
So There was a text in the hearing, a text message about the washing machine being not working on October 18, 2022. And does a washing machine, there being no washing machine working on the premises, is that substantial noncompliance or not?
So I'll answer your question, but the washing machine issue was not raised in the appeal, and so it's not a part of what you all are deciding. But any decrease in housing services without a corresponding decrease in rent or any habitability issues may arise to the level of a landlord being out of substantial compliance with the CSFRA.
So even if there was a question about the registration dates, wouldn't the washing machine also speak to if there was compliance?
Yes, but that was not the basis of the hearing officer's decision.
Okay. Was there ever anything in the hearing that mentioned the intermittent nature of the washing machine not working?
I do believe that that was raised as an issue. Okay. And I do believe that the award for the washing machine is limited because of that.
Okay. Thank you.
Alternate Balch.
Yeah, thank you. I wanted to follow up on Vice Chair Cox's question because I'm not remembering the actual facts. What was the hearing officer's basis for determining that the property was still out of compliance at the time of November 1st, 2022, if there wasn't a date for registration?
The hearing officer checked the Rent Stabilization Division's portal, and at the time that she checked it, and it is in the hearing record, it demonstrated that the property was not registered in 2021 or 2022.
Thank you.
Are there any other questions for staff? Moving on, are there any questions? Member Keating?
Thank you. Did we receive any documentation that the property was registered earlier?
No. And in the responses to committee member Cox's questions, or sorry, your vice chair, which were included. In fact, staff did end up checking, and this should not factor into your decision, but the staff did end up checking when the property was first registered, and it was in December of 2023.
Thank you.
Any other questions for staff? Otherwise, we move on to, does anyone have any questions for either the appellant or the petitioner? Member Satsislip.
I have a couple questions for the appellant, landlord. If you, I invite you up to. And please stop me if I'm doing anything outside of records. My first time doing an appeal.
No problem, I will do.
Thank you for coming today. I just have a couple of questions about when you first purchased or saw the property. Did you inspect the units or have them inspected?
I did inspect the unit, but I didn't have a professional inspector do the inspection. That's my fault.
The other question I had is, when did you first learn about rent registration requirements or any other requirements?
I only learned last year in November when this whole thing came up. I have no clue.
You mentioned, and it's in the record, that you had hired a property management company?
Yeah, they didn't inform me I need to register the property. So I wasn't aware. also, in order to, even though I hired a property management company, but I myself manage lots of the repairs because it's faster. I have some trusted contractors and handymans. I pay them the second day after they finish the work really fast, and they trust me. They come fast. If we repair things through the property management company, they have to send a ticket or a call, and then they notify the contractor. The contractor will do the work. They get owner's approval. Then 2 weeks later, or a month later, they get paid. That's how the business goes. So I end up managing lots of the repairs myself. So I don't know the registration.
I was more just, why did you choose this property management company? Is it because they managed other properties in Mountain View?
Yeah, when I did a Google search, it seems they manage other properties in Mountain View.
And what were your expectations from the property?
Also, they charge 5% instead of 10%. So I felt since they only charge 5%, I should do some of the work myself. So
I understand. I want to get more to what I'm understanding about what were your expectations for a property management company to do aside from repairs?
Yeah, the legal aspect of it, because in terms of rent, also collecting rent on time. If I collect the rent, sometimes they go late. Tenants have difficulty. It's hard for me to just go get the rent. So the main expectation for a property management company is to collect the rent on time, also be compliant. But I don't know, Mountain View has rent stabilization office. I don't know, we have to register. So to go back to Mr. Cox's question, I acquired the property in the middle of 2022. I think 3-4 months later, I engaged the property management company, let's say October, and then somehow take them 2 months to register.
Okay.
But they did register.
I appreciate you adding more information. I just, do you own any other rental properties?
No, this is the 6th unit.
Okay. When you were purchasing a rental property, did you look into any kind of laws that might govern renting property in California?
Not really. I know California have lots of laws, but I don't realize Mountain View have more strict laws.
Okay, no further questions.
All right, does any other member of the committee have any other questions for either the respondent or the appellant? Seeing none, we will move back to deliberation. Please limit your comments to the items that are appealed, as well as the potential motion that can be made at this time. Vice Chair Cox.
Yes. Okay, so I'll give you my initial take on all of this. As far as the second petition, the habitability issues, I'm on board with what's in the tentative appeal decision because, I mean, the great length of time that was taken to address the issue with the mold is not appropriate. Mold is a issue that, is a very serious one that can affect people's health. And so I agreed with the hearing officer and the staff that should have been remediated within a month of it being reported. And since it wasn't, I stand with the hearing officer's decision and the tentative appeal decision on that issue. Where I'm having a bigger concern is the fact that there's been so much lack of information and questions around the idea of when the property was registered. And so, I mean, you know, my preference would be to remand that back to the hearing officer so that we can get that into the record, since we cannot make a decision about information that was not in the record. I mean, I think that is something that is material to the amount of the decision, because it seems to me that once the property was registered, then you know, rent increases that were made after that time, you know, should not be unlawful rental increases, unless, you know, the staff can point out whether there's still outstanding issues with respect to the registration that the landlord hasn't complied with yet. So, I mean, I think that I'm uncomfortable with charging the landlord in the case where she has, for penalties after the time that she's completed the registration per the CSFRA in its completion. And so I would like to understand that better and get that information into the record. So I'm not going to make a motion right now, but I want to hear what other people have to say.
Alternate Balch.
Yeah, thank you. I wanted to first make a statement about fact and then just talk about operating, whether you're a tenant or a landlord. But I am a little confused, though, about this registration question, because when I asked staff a few moments ago, I thought I got a clear answer. So I'm not really sure what the discrepancy is there. Let me just, so first of all, I think it is important for everyone in attendance here to understand how this committee operates, to understand why the committee comes to the decision that it made tonight. The CSFRA grants this committee an extremely narrow scope and discretion. And if you remember the introduction that you heard, we are really judging whether the hearing officer came to a reasonable conclusion based on the facts provided. We are not bringing up new facts. We're not relitigating. So things, for example, a small landlord versus a big corporation, honestly, the CSFRA is neutral on that. And to the extent that there's a disagreement about how the law works, the law would have to be changed because the law is very clear on how the Rental Housing Committee operates, what it can and cannot do. Whether you're a tenant or a landlord, it is super important, I think everyone sees that tonight, to do diligence and to understand what your rights are under the law. And this applies to both sides of the lease. And to just kind of build on what my colleague was asking about earlier, I can only say, you know, please, moving forward, please do your diligence on what the law is. The law is highly unforgiving in many scenarios, and it is really, you know, for the tenant, this is where the tenant lives, and that's the roof over their head. For the landlord, it represents a substantial amount of their money and their personal livelihood. In both cases, there are substantial stakes involved, and please, for both of your protection, please understand the law. It's super important. That's my comments. Thank you.
Thank you. Member Keating.
I don't find a need to further research the date of the when the property was registered. I think that staff has already done that, and I'm satisfied that it was registered later for the first time. So there may have been misunderstanding around that, but I don't find a need to research that further. And just to echo some of committee member Balch's comments, we are doing arithmetic here and validating the arithmetic about how habitable the property was or was not at various points in time. And so that is what we can consider tonight. And, the hearing officer does the heavy lifting, and we're here to review the issues that are listed on the appeal.
Member Brown.
I have a question for council. Can you remind me, in the hearing officer procedure, what the burden of proof is on each party? If anything is raised by the petitioner, like, who is responsible for disproving that?
Yeah, so the initial burden of proof to demonstrate that a condition exists or that unlawful rent was charged is on the petitioner tenant. And then once the tenant has established that, the burden shifts to the landlord to disprove that. And it's a substantial evidence standard. And it's also a preponderance of the evidence standard, which means that it's more likely true than not true, which means that it just needs to be like a 51% likelihood that something is true versus 49% non-true in order for the tenant to have met their burden of proof, or once it shifts to the landlord, for the landlord to have met their burden of proof of demonstrating, essentially. And where there's equality between the two sides, then the tenant has not met their burden of proof.
So in the instant case, the landlord had an opportunity to rebut, like, the claim that the rent increases in 2022 were unlawful by demonstrating that they had registered prior to the rent increase.
That's correct. The landlord had an opportunity to provide evidence of the exact date on when the property was first registered. She did testify at the hearing that she believed that it had been registered at sometime at the end of December 2022, but she did not provide specific evidence. And so basically what tipped the hearing officer's decision was checking the rent stabilization portal and concluding that it had not been registered in 2022.
Thank you. So for the deliberation portion, I do not believe that the hearing officer erred or abused her discretion in holding respondent liable for unlawful rents resulting from the prior owner's failure to register the property in 2021 and 2022. And I also do not believe that the hearing officer erred or abused her discretion by concluding that petitioners were entitled to a rent reduction for the mold and moisture conditions in the affected unit. So I would move to accept the tentative appeal decision in its entirety.
Okay, a motion has been made by Member Brown, seconded by Member Keating. By moving on to the next on the list, Member Statsislip.
I just want to note that the not knowing about a law that's in place that governs a business doesn't mean you can be excused from it. You can make good faith attempts to comply with it once you learn. But there's also a duty to investigate the business you're buying. And buying any property in Mountain View is not cheap. It's a substantial investment. And it didn't sound like that in the course of purchasing that there was any investigation either into the condition of the property that you're purchasing or the laws that might govern the business you're about to enter into. And any business, a purchaser should be held responsible for doing even the bare minimum of due diligence or reasons. We say caveat emptor, buyer beware. And I asked questions about the property management company, because I believe it's a property management company that manages other properties in Mountain View. And they would be aware of the requirements under not only state law, but Mountain View. This law had been around for 5 years at that point. They should have been well aware, and they should have advised you accordingly. Or at least their questions should be asked, are there any laws that I should be aware? You said you had expectations that they would make sure you were in compliance with the laws, but that's also your responsibility as well under the law. Putting that forth, that it's not a defense in this case. If the property's not in substantial compliance, that's what the law says, that the rent increase is not, you can't lawfully increase the rent. So I do not believe the hearing officer abused her discretion or did not consider other evidence.
Vice Chair Cox, are you on cue?
So let me ask this. Does staff believe that there are still outstanding registration issues with respect to the landlord with the city of Mountain View with respect to their property? Is there something left that they still need to do as far as registration goes, other than the periodic registration that all landlords need to do?
So, I mean, I don't believe that they have any other issues. I believe they've done their registration and paid their fees. But the issue at this point is that when you've charged unlawful rents, in order to come into compliance with the CSFRA, you need to roll back any unlawful rent increases and refund any unlawful rents that were paid. So even if it was just for a month, let's just say that the rent increase went into effect, they came into compliance a month later, even if they charged unlawful rent for 1 month, they would still need to roll back the rent, refund any unlawful amounts above the lawful rent, and then reimpose the rent increase in order to be in compliance with the CSFRA. And so that is where they are now, they continue to be out of substantial compliance with the CSFRAs, because even though they registered, they never rolled back the rent and refunded the unlawful amounts and then reissued the rent increases.
Okay. So what was the mechanism for them to know that they had imposed an unlawful rent increase and that they needed to roll back the rent? Is it the only way that they, I mean, is it that the RSD staff doesn't owe them any notice on this, and that the only way that they can find out about it is to have a petition filed against them?
I mean, I will note that the CSFRA is a complaint-based system, so the primary method for enforcing it is tenants complaining about an issue. But beyond that, it is the fact that they, as Member Hislop mentioned, could have looked into the regulations and could have inquired with staff as to what they needed to do to comply with the CSFRA. And that never took place. So that if they had simply reached out to staff would have informed them of all of these things, including, and staff can correct me if I'm wrong, but when someone comes to them and they ask, have you imposed a rent increase during the time that you were not registered? If you have, then we're letting you know that you charged unlawful rents and you need to roll back the rents and refund any amounts before you can reimpose that. I'm pretty sure staff provides that information and they can confirm.
Okay, so I'm just gonna make an additional comment then and just say that, you know, I wish there were some mechanism that when somebody buys a property in Mountain View, that they would be notified of non-compliance of the person that they're buying the property from. I understand that we don't have that now, and I understand from the questions in the staff that the Rental Housing Committee is not empowered to make that happen. But I'm just making a comment on the record that there must be some legislative body that in the future could cure that problem to make it so that whoever is selling the property needs to make those disclosures. But I get it that it doesn't apply to the instant case, okay? So given what you've told me, even though I find it very unfortunate how this is all played out, I will support the motion.
Member Keating.
it is an interesting situation when a property has changed hands of how do you get the notice to the new landlord? Because you have a prior landlord who receives the notice and crumples it up and throws it away, presumably. So I think it'd also be interesting to see, to look at how to reach new landlords, but in this, that's for the future, and it is the landlord's responsibility to know the rules of the jurisdiction.
Member Balch.
Yeah, a couple comments, and in no way am I defending the CSFRA when I make these comments. I just want to explain something, like just facts for the committee here. We've had numerous examples exactly like this, where there were issues of failure to register, and therefore over many years rent increases rolled back. This is not the first time. I don't remember the count, but I know for sure we've encountered this numerous times before. This is an issue. I mean, I've made multiple speeches from this seat talking about the fact that the CSFRA has no concept of statute of limitations. To your point, it could have been a month, 10 years later. You have to roll back 10 years for that single month of noncompliance. I mean, that is a really unfortunate, in my opinion, part of the CSFRA, but that is the law. And I'm also going to say that there are all sorts of ways for property purchasers to limit or discover their liability in terms of notices of estoppel when you are discovering leases and lease terms that may be in effect. There's a whole bunch of them. So I'm just saying this is a really, really intricate, arcane bit of law in general. And it's incumbent upon anyone spending all this money to educate, because unfortunately the cost of noncompliance is very high.
Vice Chair Cox, you have further comment?
In a, I won't call it private, but in a discussion that I had with Ms. Van Dersen, she mentioned the following fact, and I'd just like to read it into the record and have you confirm it, or tell me if I did not say it correctly. Anyway, no, it has to do with banked rent increases, okay? And so it's my understanding that after all of the problems with, how this has been handled have been cured by the landlord, that she would be able to, in the future, apply for banked rent increases. And so, instead of having to follow, say, next year, the annual general adjustment, she would be able to apply for a banked rent increase of up to 10%, until she reached the point of taking credit for the previous annual general adjustments, and therefore should be able to recover money, at least, I think a substantial amount of the money that she might lose in the short term by having to fulfill the rights of the tentative appeal decision if it's adopted. Is that correct? Or would you like to say more about that?
I'm just going to say that's not a secret. It is actually in the language of the hearing officer's decision. In the decision portion, it informs the parties that once the landlord has come into compliance, they can take rent increases, including banked increases. It's part of the template language that's included in there. So,
okay, thank you. I just want to make sure the landlord heard it from us.
All right, I will speak then. I agree with aspects of comments made by my fellow committee members, that I believe there is enough evidence in the hearing regarding the issue on the registration or failure to registration. And as mentioned from Member Brown's comments, it is a duty for both sides to nitpick each other's arguments to figure out the truth. If you do not correctly argue, then you have ceded that aspect of the discussion. As regarding the discussion about the mold and moisture units. As mentioned, a lot of our discussions come down to what are the facts that can be brought to the table and whether the issue has been corrected. It is not enough to say it is being addressed, it must be corrected in its full. And as such, I too would agree with the tentative and therefore the motion. Does anyone else have any comments or discussion on the motion? Otherwise, we will go to the vote. Vote. Motion passes 5-0. All right, we will now move on to item 6.1, Charter Modernization, Proposed Amendment to the CSFRA. Public comment will occur after the presentation item and committee questions. We invite you to submit a speaker card now or raise hand on Zoom. We will begin with staff.
Good evening, Vice Chair, Chair, and RHC board members. Can you hear me okay? This is City Attorney Jennifer Logue.
You're good.
Great. The Mountain View City Council's 25-27 work plan includes a project to place a measure on the November 2026 ballot proposing amendments to the city charter to modernize its provisions. The amendments, however, contemplated for the 2026 ballot are intended to be non-controversial in nature and limited to technical and clarifying changes, including correcting typographical errors, clarifying existing language, revising outdated terminology, and improving internal consistency, etc. On February 10th, 2026, the City Council reviewed and discussed many proposed amendments, one of which was a revision to Section 17020 of the Community Stabilization Fair Rent Act to update references in that section to the Mountain View Municipal Code. The council expressed support for the proposed amendments to the CSFRA, but directed staff to seek feedback from the Rental Housing Committee, given that amendments to the CSFRA may be perceived as substantive or controversial, regardless of the scope. And so council felt that it was important to secure the RHC's understanding and support for this amendment as a step towards achieving voter approval of the overall charter amendment ballot measure. So before you on the screen, you see a proposed amendment to Section 1702 of the charter. Section 1702 provides multiple definitions of terms that are used throughout the CSFRA. Section 17020 provides the definition for relocation assistance. As it is currently written, the definition refers to sections of the municipal code which no longer exist. They've been repealed and replaced with a new Chapter 46 and provisions within that chapter. And so the recommendation that staff presented to City Council on February 10th was to amend this one portion of the CSFRA to properly refer to the new sections of the municipal code for the definition of relocation assistance, and also to add some language explaining that the references to that chapter as it now exists or may hereinafter be amended, so that in the event that the municipal code is amended again and the location of the definitions for relocation assistance are moved, the charter would already speak to referring to any new amended provisions. And so the request this evening is that you discuss and deliberate with regard to this and provide feedback on whether or not you support or have suggestions with regard to this amendment. Thank you.
Thank you. We will move on to questions from committee members. The item is limited to discussing this particular change only within the CSFRA. I put myself on cue. To the city attorney, regarding the efficacy of the language as it stands now, have we just basically locked in the language of the old section as it was when the CSFRA was initially enacted? Because I'm aware that the CSFRA was based off of East Palo Alto's ordinance, and East Palo Alto also does this weird thing where they basically locked in a semi-old version of their ordinance code just to keep references correct. Is that the same case here, or is it just in a weird situation?
I'm not sure what you mean by locked in. Could you explain a little bit more, asking if we've locked in something? We meaning the city or?
The city,
I'm
as
sorry.
in, as of right now, with this reference to dead code, is this just like a unresolved reference, or is the city supposed to look up what was the language back in 2017 when the CSFRA went into effect?
So the reference as it stands now, I suppose, I mean, the argument would be if you left it unchanged and you kept referring to, what is that, Article 13, sections 36, 38, 15, which don't exist anymore. Yes, in theory, you could go back and look at what those sections said at the time that the CSFRA was adopted. But the problem is that relocation assistance may have improved or increased, or, you know, there might be greater requirements today that you would not be getting the benefit of. So the best you could do is, yes, go back and look at what those sections said when the CSFRA was adopted, but they have been repealed. And so it really does create sort of some ambiguity and confusion, and raises the potential for arguments that those sections just are not valid because they have been effectively repealed.
Okay, thank you. Moving on to alternate Balch.
Yeah, I just want to understand, so how would this change be approved? Would it be a city council vote? Would it be a popular vote? How does that work?
So the only way the charter can be changed is by voter approval. So what you're seeing on the screen is what would be proposed, is what would be the proposed change. But there is a ballot measure that would go on the ballot. It will ask a question, you know, should the charter be amended, and it would be various things. This is not the only piece. This is just one piece of the amendment. And voter approval would be required in order to actually make the change. If voter approval is received, then the charter would reflect the change that you're seeing on the screen.
Thank you.
Council alone can't do it, no.
Right, okay, no, thank you, that makes sense. I was gonna ask about that. And so then this is gonna go onto a future ballot along with other items, as you said. Are the other items at all related to rental housing, or are they completely unrelated?
Completely unrelated, different sections of the charter. This is the only change we are seeking to make to the CSFRA. Everything else remains the same.
Thank you.
In the CSFRA, yeah.
Thank you.
Member Satsislip?
I just want to quickly ask, if this change were not made, it's always possible for somebody to challenge something in court, but could it delay a tenant's right to relocation assistance because somebody is disputing, this is if the change wasn't made, that these sections no longer apply, and it might get tied up in court, and that could cost the city some litigation, even though they would ultimately prevail? Would you agree with that?
Yes, I agree with that. It definitely could create a dispute and force us into court, yes.
All right, does anyone else have any other questions? Otherwise, I'll give another question. I'll just give a simple question. I forget, is there a limitation on how long or how many words are in the ballot language, or is that only for bonds?
Yes, there is. For a ballot measure question, it's 75 words. And so, you know, right now I'm at a limit trying to catch all of the, capture all of the other cleanup changes that we'd like to make to the charter. That's why it's, quite limited. And just to give you perspective, it's $100,000 per ballot measure. So we're only trying to put one measure on to address this cleanup of the charter.
Thank you. Vice Chair Cox.
So I'm just wondering, how many words are you using for this part of the ballot measure? I mean, are you going to be able to accurately and precisely enough indicate what the change is given the word limitation?
So that it would be as broad, it would just be as simple as, and to modify or to, it can be as broad as something like to correct references to the municipal code or to update references to the municipal code. So the ballot question itself will be very simple and broad, but what has to happen is I also have to prepare a statement of the ballot measure, and in that statement that goes along with the question, it explains everything that's going on, and it would also tell voters that they can come into the clerk's office and see all the red line changes. So the question itself is kind of broad, but it's the statement of the measure that would give details. Okay. So no, the question itself would not be really detailed about what this change looks like, but it would direct the voters on how they could get all of that information.
Okay, thank you for clarifying to me how you're going to be able to thread the needle and make this work.
Alternate Balch. Okay, I'll just give one procedural question for staff. Are we looking for a motion on this or just discussion? Okay. In the meantime, seeing no other questions on this item, we'll move on to public comment. Any member of the public wishing to provide virtual comment on this item, please click the raise hand button on Zoom or press star 9 on your phone, or submit a blue speaker card to the staff. Seeing none, we'll move back to committee deliberations and feedback. Does anyone have any discussion on it? You could quickly just say whether you're fine with the changes or something else. Vice Chair Cox.
Looks good to me.
Member Keating.
This is certainly non-controversial, and I want the overall ballot measure to pass, and I can't see this harming it, and I would certainly support this.
Member Brown.
Sure.
Does anyone else have any other deliberation or feedback on this item? Otherwise, I too would agree that this is a non-controversial change, which is fitting for a non-controversial ballot measure. I will say that once we do think of more controversial changes in the next cycle, as intended by council, that I would hope that the RHC is involved if the CSFRA does come to a discussion.
For sure.
Remember,
I feel like I have to say I agree, but I always support language that leaves flexibility for changes that may happen later on.
Okay, seeing no one else, I think that is it for this item. Thank you for coming, City Attorney.
Thank you very much.
All right, we are now moving on to item 6.2, CSFRA and MHRSO annual fee payment and registration requirements compliance. Public comment will occur after the presentation item. And committee questions. We invite you to submit a speaker card now if you'd like to speak on this item. We will begin with a presentation from staff.
Thank you, committee. I will be doing a presentation on item 6.2, which is to provide the Rental Housing Committee an update on landlord property registration and fee payment for both the CSFRA and MHRSO. And just as background, the RHC adopts the annual budget to fund the reasonable expenses to implement the programs, and the landlords and mobile home park owners pay an annual fee to fund that budget. In 2020, the Rental Housing Committee adopted mandatory registration, and in 2022, adopted late fees and fines, and the annual registration and fee are both due at the end of January each year. This year, January 31st, 2026. And any payments after that are subject to late fees and fines. And just sort of as a reminder, I guess, that's 4% per month on the balance of any unpaid rental housing fees. And for non-compliance with registration, that's $25 per unit per month. And so you'll see a chart here on our outreach efforts, and staff conducts pretty extensive outreach and education efforts during each annual cycle for fee payment and registration. As you'll see for workshops and webinars, it says 3. I've actually done 1 since this memo, so it's 4 for 2026. We have done targeted outreach and mailings, but I did sort of want to mention that as internally, we are trying to automate a lot of our outreach. So you'll see that with our latest new feature for the direct mailings to landlords who are not in compliance with either the registration or the fee payment component of requirements. We automated a direct email system that goes out on the 1st of each month through our portal, and it will actually identify which piece of the requirement the landlord is not in compliance with. So it would either be fee payment, registration, or both. And then it would tailor the email to actually let them know how to comply with each of those. So it individualizes it in a way for each landlord, which is really nice. So in January or February 1st, we sent out 84 of those individual personalized emails, and then we noticed within about a week or two, we had 25 properties take immediate corrective action, which is great, and that will continue every month throughout the year. So we are anticipating that that will actually really increase and help our compliance levels. And also, right now, staff is coordinating to send out our first compliance letters in the next week or so. And this, I just sort of wanted to let you see some of our outreach that we send out to landlords. So we do some workshops, we have postcards, we send out a lot of email blasts, especially leading up to the due dates. And then the bottom right here is just an example of the new tailored email messages that go out through the portal. And then here we're going to talk specifically about CSFRA compliance. And you'll see the table to the left is fee payments, and then the table to the right is registration compliance. So looking at both, if we look at the compliance rate for the January 31st deadline, we'll notice that that has increased year over year, especially I think due to some of our compliance measures that we implemented with the late penalties and the compliance letters and things like that. And so we continue to sort of be at our all-time highs or very near where our all-time high was. And then I did want to mention to date, as of 4 o'clock today, we are at 90% compliance with both fee payment and registration. And in 2 more days, another email blast will go out, and I'm hoping that that will increase even more. But we do anticipate, again, that by the end of the year, our compliance percentages will be increased. And with mobile home compliance, it is at 100% before the January 31st deadline, so we are already at 100% compliance for the year, for both fee payment and registration. And for fiscal impact, providing this information to you has no fiscal impact. Any questions?
Does anyone have any questions? Vice Chair Cox, I'm guessing you want to give a question?
Oh, I just want to make a couple comments.
Questions first?
Questions first, so I'll wait for my comments.
Member Keating.
So I'm happy that you included the email. It's a little hard to read, it's kind of small. And so is it an exact copy that goes to the, gets copied to the tenants, or is it a little different?
Yeah, so this is a little bit different. This is This is an email that's going out to the owner and their managers at the first of every month. And it's only targeted to properties that are not in compliance with either fee payment or registration. And it's just really a reminder, the email. It's the compliance letter that goes out, and that goes out by mail that we're sending out. And then after 30 days of that, if that issue is still not corrected, a copy of the compliance letter will be sent to the tenant.
And a copy of it, I mean, is there like a cover letter saying,
yeah, there's
the
a
tenant saying this is what we sent to your landlord, or?
Yeah, there's a very short cover letter, and it's translated in all languages, and it says the property, may be out of compliance with CSFRA. If you've received a rent increase, please contact our office, or if you have any other concerns, please contact our office. And a copy of the compliance letter is attached to this letter. And so we attach the compliance letter and then also translate the compliance letter in all the languages so that they're able to read what was sent to the landlord in any of the languages.
Does anyone else have any questions on this topic? I'll just give one question, which is, at this point, do we just see the same people non-compliant year after year, or does it change?
It changes slightly, but for the most part, it is sort of the same people. We have done a lot of research and worked with other departments in the city to try to find proper mailing addresses and contact information, and check with the county. So we continue to do that every year in hopes to get a hold of them, but it is generally the same people.
Member Sislip?
I did have a question, but since you've addressed it, I'll ask it. Is if you get returned mail from a landlord, what actions do you take?
Yeah, so we do keep that, and we have a spreadsheet, and then we look for alternate owners or mailing addresses in the places that I mentioned, and send mail to all of them in hopes that someone will respond. And then sometimes with the second compliance letter, if the tenants come in, we also ask the tenants if they have information.
All right, we will move on to public comment. If you would like to give comment on this item, please press *9 on your phone, raise hand on Zoom, or submit a blue speaker card. Seeing, actually, we do have one comment.
Bill Cosby, you can unmute yourself.
Right, thank you. So if I'm reading this slide correctly, you've got greater than 96% registration compliance. Is that correct?
Correct.
Wow, I think that's a pretty good job. Thank you.
All right, Phil. Okay, we are now bringing it back to committee deliberations and feedback. Does anyone have any further discussion on this item? Vice Chair Cox.
Yeah, I just want to make a couple comments. First of all, I was going to say I was glad to see that the fee compliance by January 31st had improved to 4%, but now I'm going to say 7%. So thank you for going above and above even what was in the staff report. I'll echo what Chair Ma had said about, we seem to still have a persistent small percentage of non-compliance, this 4%. And it seems, I understand that even though the public commenter likes 96%, I mean, I've made the analogy from times that if 4% of the people in Mountain View didn't pay their property taxes, I would consider that to be an alarming situation. And so I appreciate the fact that you're looking into trying to figure out, what's going on about this, and in particular, that you're trying to figure out whether it's the same 4% of landlords that are not in compliance, because that to me is a more serious issue than something that eventually gets resolved. So I hope that you'll keep working on that, and I would encourage that if it's sometime in the future, you can put an item on the agenda, to tell us what your progress is so that we can understand it in more detail, I would appreciate that.
Any other discussion on the item? And also we can clear out the timer at this point. Seeing none, I will give a few more comments, which is that, at this point, either, I have a funny feeling that the remaining sites probably don't have tenants at this point, or if they do, I don't know, maybe they would just stop paying rent increases. I don't know. Because as we mentioned in our second non-compliance letter, we do make it very clear that the landlord loses the ability to raise their rents. But obviously, as mentioned before as well, CSFRA is a complaint-based system, so unless they pull the trigger, we can't really do very much as of right now. And as such, that's my comments. So in that case, seeing no other persons, we will now move on to the next item, which is committee staff announcements and updates.
Thank you. All right. As usual, we continue to have our virtual office hours every Tuesday morning from 10 to noon. Those are only online. And we do have a new batch of workshops coming up. So March 24th in the evening, we have Understanding the Utility Adjustment Petition focused for tenants so they can understand those adjustments that might be coming their way. And then in April, you'll see we have a batch of sort of fair housing related workshops that we're partnering with Project Sentinel for during Fair Housing Month. So April 7th, both in the afternoon for landlords and in the evening for tenants, there is a general fair housing overview workshop. And on April 14th, at 6:30 p.m., there's a rights and responsibilities for leasing an apartment that's tenant focused. And we continue to keep our Housing Help Center for landlords every Thursday from 1 to 3 p.m., both in person and virtual. And our tenant Housing Help Center is the first and third Thursdays, which is rent stabilization staff, as well as our partners in Project Sentinel, CSA, and CLUSPA for tenants to come in the evening, both in person and online. We are also attending the Lunar New Year celebration on Saturday, which we're very excited about. Any questions on any outreach?
I have a question, two-part. One part is regarding the tenant aspect of the utility adjustment petitions. Are we seeing a certain amount of comments on this topic, or just at this point, people just have questions?
We are seeing some tenants in certain buildings who are actually receiving the adjustment notices utilize the response forms, which has been great. And we have been working with those tenants to sort of investigate those petitions. So that's been very useful. And then separately from that, I think staff is doing a lot of just clarifying and education, because it is a little bit confusing to sort of understand that RUBS is disappearing, but it's sort of going into your rent, which will then be stabilized. So there's just it's a lot to sort of wrap your head around. So we're doing a lot of education on that. So we hope that the workshops we can talk to more people at once than always one-on-one.
Okay, thank you. My other one is about the retaliation anti-harassment regulations we made a few months back. I wonder how have those been communicated to tenants and landlords? Would they be part of these kind of sessions, or would they be part of like the newsletter?
All of the above. Okay. We're in the process of making a communication plan with outreach, workshops, materials, and newsletters and materials. Yeah.
Thank you. And a reminder for everyone else that the Lunar New Year event will be this Saturday, 10 to 2, I believe, at the community center. Is that correct? Okay. Does anyone else have any comments or questions? Seeing none, we will move on to item 7.2, expected future agenda items for our two members. There is nothing.
I just want to emphasize there is on your work plan, there is an update on the trail, but that currently is the only agenda item. There's no appeal for March, so I was wondering if we could postpone the March and then just add that item to the April agenda.
Does anyone object to not having a March meeting? Alternate Balch?
I actually can't attend, so that's fine with me.
Okay, that's a vote for it. Member Keating?
Is this the first time we've deferred a meeting, or it's happened before?
It's very, very rare that it happened before, yeah.
I don't see any objection to skipping the March meeting. Does anyone else have any final comments? Otherwise, this meeting is adjourned at 7:55 p.m. The next rental housing committee is scheduled to be held March 26th at 6 p.m., but we'll see when it actually is.
We'll definitely publicate that that meeting has been canceled and what the
Yes.
next following meeting is going to be.
Meeting adjourned.